The courthouse hallway smelled of floor polish and recycled air. Sarah Collins stood motionless outside courtroom 4B, her fingers gripping the strap of her leather bag hard enough to leave marks on her palm. Through the narrow window in the oak door, she could see the gallery filling with faces, some curious, some already convinced of her guilt. Her attorney, Linda Pacheco, touched her elbow gently. "Ready?" Sarah nodded, though her throat had gone dry. She had taught American history to teenagers for 11 years. She had explained the presumption of innocence countless times, had assigned essays on the Sixth Amendment, had believed in the system with the kind of earnest faith that now felt like naivete. The door opened. Every head in the courtroom turned toward her as she walked down the center aisle. Sarah kept her eyes forward, focusing on the defense table, on the simple act of placing one foot in front of the other. Her navy blazer felt too tight across her shoulders. She had bought it specifically for this, something professional, something that said innocent schoolteacher, not woman who would fabricate a crime to destroy her ex-boyfriend. Judge Rebecca Holloway was already seated, her expression unreadable behind rimless reading glasses. The judge's gray hair was cut short and precise, and when she looked up from the papers before her, Sarah felt the weight of 25 years of judicial experience in that single glance. "All rise." The courtroom rustled to its feet. Sarah remained standing as the clerk read the charges. The words blurred together: conspiracy to file a false police report, obstruction of justice, criminal mischief. Each one felt like a stone being added to a growing pile on her chest. 48 hours earlier, she had been in her classroom, discussing the Constitutional Convention with her third-period students. Detective Owen Marshall had walked in halfway through her explanation of the Great Compromise, his badge clipped to his belt, his face professionally neutral. "Miss Collins, I need you to come with me." The students had gone silent. Sarah had set down her dry erase marker, her hand surprisingly steady, and followed him into the hallway. I remembered the fluorescent lights flickering overhead, remembered thinking absurdly that maintenance still hadn't fixed them after 3 weeks. "You're under arrest for filing a false police report and conspiracy to commit fraud." The handcuffs had clicked shut around her wrists in front of 27 teenagers pressed against the classroom door window. Now in the courtroom, Sarah sat as instructed. Linda settled beside her, arranging files with practice efficiency. Across the aisle, District Attorney Michael Brennan was speaking quietly with his assistant, a younger woman whose name Sarah had already forgotten. Brennan's red hair caught the light from the tall windows. He had the lean, focused look of a marathon runner, and Sarah had read enough about him to know he rarely lost. Judge Holloway looked out over the courtroom. "Mr. Brennan, your opening statement." The prosecutor rose, buttoning his jacket in a single smooth motion. He approached the jury box, 12 faces that would decide whether Sarah's life continued or shattered completely. "Ladies and gentlemen of the jury, this case is about deception." Brennan's voice carried easily through the room, conversational but authoritative. Not the deception of strangers, but something far more calculated. The deception of someone who understood exactly how the system works and decided to exploit it. He gestured toward a photograph on an easel. Sarah's house, the modest 2-bedroom Cape Cod she had bought 5 years ago with money inherited from her grandmother. On the night of September 14th, the defendant called 911 to report a burglary. She told police that someone had broken into her home, ransacked her belongings, and stolen jewelry valued at approximately $15,000. She provided police with text messages, threatening messages, allegedly sent by her ex-boyfriend, Trevor Hammond, messages that painted Hammond as angry, unstable, dangerous. Brennan paused, letting his words settle over the jury. The police investigated. They found the defendant's home in disarray. They found the broken door lock. They found no fingerprints except those of Miss Collins and Mr. Hammond, understandable, given their prior relationship. Everything appeared to support her story. He turned, and for the first time looked directly at Sarah. But appearances, as we will demonstrate, can be carefully constructed. The prosecution will show that Miss Collins staged this burglary herself, that she destroyed her own property, hid her own jewelry, and manipulated evidence to frame an innocent man, all because she could not accept that their relationship was over. Sarah felt her jaw tighten. She forced herself to keep her hands still, flat on the table. Linda had coached her on this. No visible reactions, no matter what was said. We will present evidence of internet searches on the defendant's computer. Searches for how to file police reports, how to document harassment, how to obtain restraining orders. We will show you that Miss Collins had both motive and opportunity, and we will prove beyond reasonable doubt that she is guilty of every charge brought against her. Brennan returned to his seat. The courtroom was utterly silent. Judge Holloway nodded to Linda. "Miss Pacheco, your opening statement."
Meant. Linda stood without hurry. She walked to the jury box and stopped, studying each face for a long moment before speaking. Trevor Hammond had a key to Sarah Collins's house 3 months after their relationship ended. Her voice was quieter than Brennan's, but it carried its own kind of power. The prosecution will ask you to believe that Sarah destroyed her own home, hid $15,000 worth of jewelry, and risked criminal charges, all out of spite. But they will not explain why Mr. Hammond still had access to her home. They will not explain his financial desperation. And they will not explain why the police closed this investigation in 4 days without examining any alternative theories. Linda moved along the jury box, making eye contact with each juror in turn. Sarah Collins is a teacher. She has no criminal record, no history of violence or dishonesty. When her relationship with Trevor Hammond ended, she went to therapy. She focused on her work. She moved forward with her life. And then one night she came home to find her house destroyed and her property missing. She paused. The prosecution will tell you this is about deception. They're right. But the deceiver is not the woman sitting at that table. Over the course of this trial, you will learn who really manipulated evidence, who really had something to gain, and who really committed a crime. Linda returned to her seat. Sarah exhaled slowly, trying to calm the rapid beating of her heart. Judge Holloway adjusted her glasses. Mr. Brennan, call your first witness. The people called Detective Owen Marshall. Marshall walked to the witness stand with the measured gait of someone who had done this hundreds of times. He was sworn in, his voice steady and professional as he confirmed his name and rank. Brennan approached. Detective Marshall, you responded to a 911 call on the night of September 14th. Can you describe what you found? I arrived at 42 Maple Grove Road at approximately midnight. The defendant, Miss Collins, was waiting outside. She appeared distressed. She told me she had come home from dinner with a friend and found her front door ajar. What did you observe inside the residence? Marshall consulted his notes, though Sarah suspected he had memorized every detail. The living room was in significant disarray. Couch cushions were on the floor, books pulled from shelves, drawers emptied. The bedroom showed similar damage, clothing scattered, jewelry box overturned and empty. The back door showed signs of forced entry. The frame around the lock was splintered. Did you find any indication of who might have committed this burglary? Miss Collins told me she suspected her ex-boyfriend, Trevor Hammond. She showed me text messages on her phone, messages that appeared threatening in nature. Brennan projected images onto a screen, close-ups of texts that Sarah had read so many times she knew them by memory. You should have listened to me. This isn't over. You'll regret what you did. Sarah stared at those words, remembering the sick feeling in her stomach when she had first seen them, 3 days before her house was destroyed. Linda leaned close and whispered something Sarah could not quite process. Her mind was still fixed on those messages, on the memory of Trevor's voice, on the question that had kept her awake for 3 months. Had she really been so blind? Judge Holloway called for a recess. Sarah stood mechanically, following Linda toward the side door. What no one in that courtroom yet knew was that somewhere in the police evidence room, buried in a box labeled Collins, Case 47293, was a single receipt, time-stamped and geotagged, that would unravel everything Michael Brennan had just promised to prove. The afternoon light slanted through the courtroom windows as Detective Marshall settled back into the witness stand. His expression remained professionally neutral, though Sarah noticed the way his thumb worried at the edge of his notepad, a small tell that suggested this testimony was not as routine as his tone implied. District Attorney Brennan approached with a manila folder in hand. Detective Marshall, let's walk through the crime scene investigation in detail. You arrived at midnight on September 14th. What was your initial assessment? Marshall cleared his throat. The residence showed clear signs of forced entry. The back door's lock mechanism was damaged, and wood splinters were visible on the floor near the threshold. This was consistent with someone using a pry bar or similar tool. Why the back door specifically? The front door had a newer deadbolt. I later learned Miss Collins had it installed approximately 5 months prior. The back door still had the original builder's lock, which was significantly weaker. Sarah remembered that detail with painful clarity. She had meant to replace both locks after Trevor moved out, but the front door had seemed more urgent. The back door opened onto a small fenced yard that felt private, protected. She had told herself she would get to it eventually. Eventually had come too late. Brennan projected photographs of the crime scene. Sarah forced herself to look at them. Her living room transformed into chaos. Her grandmother's quilt crumpled on the floor. The ceramic lamp she had bought at a craft fair shattered against the wall. What else did you observe? The bedroom was similarly disturbed. Drawers were pulled out, contents scattered. The jewelry box on the
dresser was empty. Miss Collins reported that several pieces were missing: a sapphire pendant, pearl earrings, a gold bracelet, and 2 rings. Total estimated value of $15,000. Did you process the scene for fingerprints? We did. The forensics team lifted multiple prints from doorknobs, furniture, and the jewelry box. All matches came back to either Miss Collins or Trevor Hammond. Mr. Hammond's fingerprints were in the home. Yes, Miss Collins explained they had been in a relationship for 2 years and that he had lived there intermittently. His prints were expected in common areas. Brennan paused, letting the jury absorb this information. Did Miss Collins provide any specific evidence suggesting Mr. Hammond was responsible? Marshall nodded, scrolling through his phone to find the relevant notes. She showed me text messages from an unregistered number. The messages referenced their recent breakup and contained language that could be interpreted as threatening. Miss Collins believed the number belonged to Mr. Hammond. Could be interpreted, Brennan rechated, but were they explicitly threatening? They were ambiguous. Phrases like, "you'll regret this," and "this isn't over," could indicate either emotional distress or genuine threat, depending on context. Sarah remembered showing those messages to Marshall, her hands shaking as she scrolled through them. She had been certain, absolutely certain, that Trevor was behind them. The phrasing, the timing, the specific references to arguments only he would know about. Brennan displayed the messages again on the screen. "Detective, how long did the initial investigation take?" 4 days. We interviewed Mr. Hammond on September 16th. He denied sending the messages and provided an alibi for the night of the 14th. He stated he was at a casino in Atlantic City. Did you verify this alibi? Marshall shifted slightly in his seat. We contacted the casino. They confirmed Mr. Hammond had used his rewards card at a poker table between 9 p.m. and 1:30 a.m. on September 14th. So his alibi checked out. The casino was approximately 2 hours from Miss Collins's residence. The timeline would have been tight, but not impossible. Brennan let that hang in the air before continuing. What led you to suspect Miss Collins had fabricated the burglary? Several factors raised concerns. First, the damage to the back door appeared staged. The splintering was superficial and could have been created from the inside. Second, nothing else of significant value was taken. The television, laptop, and other electronics were untouched. Only the jewelry was missing. And jewelry is easily hidden. Correct. We also examined Miss Collins's computer during the investigation. Her search history from the week prior to the incident included queries about filing police reports and obtaining restraining orders. Sarah felt her face flush. She had made those searches. She remembered them clearly. After receiving the threatening messages, she had researched her options. She had wanted to know what legal protections were available. Now those same searches were being used as evidence of premeditation. When did you make the decision to charge Miss Collins? After consulting with the district attorney's office, we determined there was sufficient evidence to support charges of filing a false police report and related offenses. Brennan nodded, satisfied. No further questions. Judge Holloway looked to the defense table. Miss Pacheco, your witness. Linda rose, gathering her notes with deliberate slowness. She approached the witness stand without hurry, studying Marshall with an expression that gave nothing away. Detective Marshall, you mentioned processing the crime scene took place overnight on September 14th into the 15th. How many officers were present? 3, myself and 2 forensic technicians. And how long were you at the residence? Approximately 3 hours. 3 hours to photograph, dust for prints, collect evidence, and interview Miss Collins? Marshall frowned slightly. That's standard for a burglary investigation. Is it also standard to close an investigation entirely within 4 days? When the evidence is clear, yes. Linda picked up a document from her table. You testified that you examined Miss Collins's computer and found search history related to police reports. Did you examine the metadata on those searches? The what? The metadata. The digital information that includes timestamps, IP addresses, device information, the kind of data that tells you not just what was searched, but when and from where. Marshall's jaw tightened almost imperceptibly. We noted the dates of the searches. But you didn't verify the specific times those searches were conducted? The dates were sufficient for our purposes. I see. Linda's tone remained neutral, but Sarah sensed the shift in momentum. Detective, you mentioned that Mr. Hammond's alibi placed him at a casino in Atlantic City. Did you obtain surveillance footage from the casino? We confirmed his card usage. That's not what I asked. Did you request video surveillance to verify he was physically present at the poker table during those hours? Marshall hesitated. Card usage is generally considered reliable verification. Generally. But you didn't request the video. No. Did you check his vehicle for any evidence that might connect him to the crime scene? Mr. Hammond's vehicle was not impounded, so that's also a no. Linda consulted her notes. You testified that electronics were left untouched in Miss Collins's home. Did you consider that a burglar specifically targeting jewelry might have known where to look and what to take? It's possible. Did you investigate whether Mr. Hammond had knowledge of where Miss Collins kept her jewelry? Given their relationship, he would have had such knowledge. So he would have known exactly what to take and where to find it. Brennan rose. Objection. Counsel is leading the witness toward speculation. Judge Holloway considered. Overruled. The detective may answer. Marshall shifted in his seat. He could have known, yes. Linda moved closer to the witness stand. Detective, you mentioned that Miss Collins had changed her front door lock 5 months before the incident. Did you ask her why? She said it was after Mr. Hammond moved out. So she took active steps to secure her home after the relationship ended. That's what she claimed. Claimed, Linda repeated. Detective, when you closed this investigation after 4 days, had you investigated Mr. Hammond's financial situation? That wasn't relevant to. Had you checked whether he had any debts, any financial pressures that might motivate theft? Marshall's expression hardened. No. Had you interviewed any witnesses other than Miss Collins and Mr. Hammond? We spoke with Miss Collins's friend, Jessica Parnell, who confirmed she had dinner with Miss Collins on the night of the 14th. Anyone else? A neighbor reported seeing activity at the residence, but the timing was unclear. Linda paused, letting the silence stretch. So, within 4 days, without verifying Mr. Hammond's alibi through video evidence, without examining his vehicle, without investigating his finances, and with minimal witness interviews, you concluded that Miss Collins had fabricated this crime. The evidence supported that conclusion. Did it? Or did you simply stop looking for evidence that might contradict it? Brennan stood. Objection. Argumentative. Sustained. Judge Holloway looked at Linda. Move on, counselor. Linda gathered her papers. No further questions. As Marshall stepped down from the witness stand, Sarah caught his eye for just a moment. She saw something there. Not quite doubt, but perhaps the first crack in his certainty. Judge Holloway checked the time. We'll adjourn for today. Court will resume tomorrow morning at 9. The gavel struck wood, and the courtroom began to empty. Sarah remained seated, staring at the photographs of her destroyed home still displayed on the screen. Linda touched her shoulder. That was good. We planted questions in the jury's mind. Sarah nodded, but her attention was fixed on one particular photograph, a wide shot of her bedroom. In the background, barely visible, was her nightstand. And on that nightstand was something that suddenly seemed desperately important. A framed photograph, still standing upright and untouched. A photograph of her and Trevor, taken during a weekend trip to the mountains. If someone had truly ransacked her bedroom in anger, why would they leave that photograph intact? Trevor Hammond looked exactly as Sarah remembered, perhaps even better. His dark hair was styled with precision, his charcoal suit tailored perfectly across his athletic frame. He walked to the witness stand with the easy confidence of someone accustomed to making good impressions, someone who sold expensive homes to wealthy clients by projecting trustworthiness and charm. Sarah's stomach twisted as he was sworn in. District Attorney Brennan approached with an expression of professional sympathy. Mr. Hammond, thank you for being here. I know this is difficult. How long were you in a relationship with the defendant? Trevor's green eyes flickered briefly toward Sarah before returning to Brennan. 2 years, from March 2021 to March 2023. And you lived together? Not officially. I kept my own apartment, but I stayed at Sarah's house 3 or 4 nights a week. I had clothes there, toiletries. For practical purposes, yes, we lived together. Can you describe the relationship? Trevor leaned back slightly, his posture suggesting reluctant honesty. It started well. Sarah was intelligent, passionate about her work. We had a lot in common. But over time, things became complicated. Complicated how? Sarah had difficulty with boundaries. If I needed space, she interpreted it as rejection. If I went out with friends, she needed detailed explanations. After about a year, it started feeling suffocating. Sarah felt Linda's hand briefly touch her arm under the table, a reminder to control her reaction. But the words stung because they contained fragments of truth twisted into something unrecognizable. She had asked questions when Trevor disappeared for entire weekends. She wanted to understand why he became distant and irritable. That wasn't suffocating. That was trying to communicate. Brennan nodded sympathetically. When did you decide to end the relationship? Early March this year. I told Sarah I needed to focus on my career and that I thought we wanted different things. She didn't take it well. What do you mean? She cried, asked me to reconsider. I explained that my decision was final. I moved my belongings out over the next week. I thought that would be the end of it. But it wasn't? Trevor shook his head.
Head slowly. Sarah started sending emails, long messages about how we could make it work, how she would change. I responded a few times, trying to be kind but firm. Eventually, I stopped replying. Brennan displayed several emails on the screen. Sarah recognized them immediately. Messages she had sent in the first raw weeks after the breakup, before therapy, before she had learned to process the grief and move forward. Please, we can fix this. I miss you. Can we at least talk? I don't understand what happened. We were good together. The words looked desperate, projected 10 feet tall. Sarah wanted to explain the context, that these were sent over 3 weeks, not daily harassment,
that she had stopped entirely after starting therapy in April, but context dissolved in a courtroom. Mr. Hammond, were you responsible for the text messages Miss Collins showed to police, the threatening messages? Absolutely not. I don't even know what number those came from. After I stopped responding to Sarah's emails in early April, I had no contact with her. Did you break into her house on September 14th? No. I was in Atlantic City that night. I go there occasionally to play poker. It helps me unwind. I used my rewards card at the Tropicana. The casino has records. Brennan paused, shuffling his papers. Mr. Hammond, the prosecution has introduced evidence that Miss Collins searched online for information about filing police reports and obtaining restraining orders. From your knowledge of her, does this surprise you? Linda stood immediately. Objection. Calls for speculation about the defendant's state of mind. Judge Holloway considered. I'll allow it. The witness may answer based on his personal experience with Miss Collins. Trevor clasped his hands, the picture of reluctant candor. It doesn't surprise me. Sarah researches everything exhaustively. If she decided to pursue some course of action, she would learn every detail first. Thank you, Mr. Hammond. No further questions. Judge Holloway nodded toward the defense table. Linda stood, adjusting her suit jacket as she approached. She studied Trevor for a long moment before speaking. Mr. Hammond, you testified that you moved your belongings out of Miss Collins' house in March. Did you return your key? Trevor hesitated for the first time. I don't recall. I might have left it on the counter. You might have. So it's possible you still had a key to her residence as recently as September? If I did, it was an oversight. An oversight. Linda's tone remained neutral. You also testified that you stayed at Miss Collins' house 3 to 4 nights per week for 2 years. You knew the layout well? Of course. You knew that the back door had an older, weaker lock compared to the front door? Trevor's jaw tightened almost imperceptibly. I never paid attention to the lock specifically. Really? In 2 years, you never noticed that the front door had a newer deadbolt and the back door didn't? I may have noticed. I don't remember. Linda moved to her table and picked up a document. Mr. Hammond, you mentioned going to Atlantic City to play poker. How often would you say you visit casinos? Once or twice a month. And how much do you typically wager? Brennan rose. Objection. Relevance? I'm establishing the witness's financial circumstances, Your Honor. Judge Holloway nodded. Overruled. The witness will answer. Trevor shifted in his seat. It varies. Sometimes a few $100s, sometimes more. Sometimes more, Linda repeated. Mr. Hammond, do you currently have any outstanding debts? I have normal expenses like anyone else. That's not what I asked. Do you have debts beyond typical living expenses? Credit cards, personal loans, gambling debts? The charm drained from Trevor's expression, replaced by something harder. I don't see how that's relevant to whether Sarah fabricated a burglary. Please answer the question. I have some credit card balances. How much? Trevor's hands gripped the armrests of the witness chair. I'm not sure of the exact amount. Linda consulted her notes. According to credit reports obtained through Discovery, you had approximately $38,000 in credit card debt as of September of this year. Does that sound accurate? The courtroom was utterly silent. Sarah stared at Trevor, genuinely shocked. $38,000. He had never mentioned financial problems during their relationship. He drove a new BMW, wore expensive watches, took her to upscale restaurants. That's private financial information. It's relevant financial information, Mr. Hammond. You also testified that you go to Atlantic City to play poker. Have you ever borrowed money to gamble? Objection, Brennan interjected. This line of questioning is designed to prejudice the jury against the witness without establishing clear relevance. Judge Holloway looked at Linda. Counselor, connect this to your case. Linda nodded. Your Honor, the defense will demonstrate that Mr. Hammond had significant financial motivation to steal and sell Miss Collins' jewelry. His debts establish motive. Proceed. Linda turned back to Trevor. 1 week before Miss Collins reported the burglary, did you visit her? Trevor's expression flickered with surprise at the shifting questioning. I may have. You may have. Miss Collins would testify that you appeared at her door on September 7th, asking to borrow money.
Money? Do you recall that? We spoke briefly. You asked her for $15,000. She declined. Is that accurate? Trevor's face flushed. I mentioned I was going through a rough patch financially. It was a conversation, not a formal request. And she said no. She said she couldn't help. Linda paused, letting the jury absorb this. Mr. Hammond, you testified that you had no contact with Miss Collins after April, but you just admitted visiting her in September. Which statement is true? I meant no meaningful contact. This September visit was brief and unrelated to our past relationship. Unrelated. You asked your ex-girlfriend for $15,000, the exact value of the jewelry later reported stolen, and you consider that unrelated. Brennan stood again. Objection, argumentative. Sustained. Miss Pacheco, rephrase. Linda gathered her papers. Mr. Hammond, you testified that you stopped at the Tropicana in Atlantic City on September 14th. What time did you arrive? Around 8:30 or 9 p.m. And what time did you leave? After 1 a.m. Atlantic City is approximately 2 hours from Miss Collins's residence in Havenfield, is that correct? Roughly, yes. So you would have had time to drive to Haddonfield, enter Miss Collins's home, and return to Atlantic City within that time frame. That's absurd. I was at the casino the entire time. You testified that you used your rewards card. Does the casino require you to use the card continuously or only at the beginning and end of play? Trevor's expression hardened. I don't know the technical details of their system. So it's possible you could have checked in at 9 p.m., left the casino, and returned hours later. I didn't leave. But you can't prove that with certainty. The casino has cameras. Did you request that footage be preserved? Trevor stared at her, realizing the trap. No. So that footage may no longer exist. Linda closed her folder. No further questions. As Trevor stepped down from the witness stand, his confidence visibly shaken, Sarah noticed something she had missed during their entire relationship. When he was cornered, when the charm stopped working, his left hand formed a fist so tight his knuckles went white. She had seen that gesture before. The night she told him she wouldn't lend him money. The night she had locked her front door after he left and felt for the first time genuinely afraid. Judge Holloway announced a 15-minute recess. Sarah turned to Linda. You knew about his debts. Linda nodded. Discovery provided access to financial records. He was drowning Sarah. And desperate people make dangerous choices. Sarah looked back at Trevor, who was speaking in low, angry tones with Brennan near the prosecution table. For 2 years, she had believed she knew him. Now she wondered if she had known him at all. Jessica Parnell walked to the witness stand with the kind of steady composure that came from years of dealing with medical emergencies. Her curly brown hair was pulled back in a loose ponytail, and she wore simple navy slacks with a cream blouse. She offered Sarah a quick, reassuring smile before being sworn in. Linda approached with a warmth that had been absent during her cross-examination of Trevor. Miss Parnell, how do you know Sarah Collins? We've been best friends since college, 14 years now. Would you say you know her well? Very well. We talk almost every day. We've been through job changes, family losses, relationships. She's like a sister to me. Were you aware of her relationship with Trevor Hammond? Jessica nodded. I was. I met Trevor several times. Sarah seemed happy initially, though toward the end I noticed she was more stressed. Stressed how? She second-guessed herself more. She would apologize for things that didn't need apologies. Small things, like suggesting a restaurant or asking if I wanted to meet for coffee. It was subtle but noticeable. Linda pulled up a calendar on the projection screen. Miss Parnell, were you with Sarah on the evening of September 14th? Yes, we had dinner at Marino's Italian Kitchen. We arrived around 7:30 and left around 11. How did Sarah seem that evening? Honestly, better than she'd been in months. She was lighter, laughing more easily. She told me her therapist had helped her work through a lot of the post-breakup feelings. She felt like she was finally moving forward. Did she mention Trevor at all? Jessica thought for a moment. Only once. I asked if he'd been bothering her, and she said no. She mentioned he'd come by the previous week asking for money, which surprised me, but she said she'd declined and hadn't heard from him since. Linda consulted her notes. After dinner, what happened? I drove Sarah back to her house. I pulled into her driveway around 11:15. We sat in the car talking for maybe 10 more minutes, just catching up on small things. Then she went inside and I drove home. Did you notice anything unusual about her house or the surrounding area? No, everything seemed normal. The porch light was on, no cars I didn't recognize. It was a quiet residential street. When did you next hear from Sarah? Jessica's expression grew troubled. She called me around 12:30 a.m. She was crying, barely coherent. She said her house had been broken into and the police were there. I drove straight back. What condition was Sarah in when you arrived?
She was sitting on her front steps, wrapped in a blanket one of the officers had given her. She was shaking, not from cold, from shock. I've seen trauma in my work as a pediatric nurse. Sarah was genuinely traumatized. In your 14 years of knowing Sarah Collins, have you ever known her to lie or manipulate situations for personal gain? Never. Sarah is one of the most honest people I know. She's the friend who will tell you the truth even when it's uncomfortable. That's who she is. Linda nodded. No further questions. Brennan rose, buttoning his jacket as he approached. Ms. Cornell, you testified that you and Miss Collins are very close friends. Best friends, in fact. That's correct. So you would want to help her in a difficult situation. Jessica's expression cooled slightly. I would want to tell the truth, which is what I'm doing. Of course, you mentioned that Sarah seemed stressed toward the end of her relationship with Mr. Hammond. Did she ever express anger toward him? She was hurt, not angry. There's a difference. But hurt people sometimes act irrationally. Objection, Linda interjected, calls for speculation. Sustained. Brennan shifted tactics. You stated that Sarah told you Trevor had asked for money. Did she seem upset about that?
She seemed surprised more than upset. She said he'd never mentioned financial problems before. And when you dropped Sarah off at 11:15, you noticed nothing unusual, but 30 minutes later she discovered a burglary. That's a very narrow window. Jessica met his gaze steadily, which suggests someone who knew her schedule and knew she'd be out that evening. Brennan's jaw tightened. No further questions. As Jessica stepped down, she caught Sarah's eye and mouthed, "It's okay." Judge Holloway checked her notes. "Mr. Brennan, your next witness." The people call Philip Yates. Sarah watched as an elderly man with sparse white hair made his way slowly to the witness stand, leaning heavily on a wooden cane. She recognized him vaguely as the man who lived 3 houses down, someone she'd exchanged pleasantries with while collecting mail, but had never really known. Yates settled into the witness chair with visible relief, adjusting thick-framed glasses that magnified his pale blue eyes. Brennan approached with exaggerated gentleness, as if speaking to someone fragile. "Mr. Yates, where do you live?" 36 Maple Grove Road. I've been there 32 years. So you live on the same street as Miss Collins? Yes, her house is 3 doors down on the opposite side. On the evening of September 12th, 2 days before the reported burglary, did you observe anything unusual? Yates nodded slowly, his hands gripping the cane. I was having trouble sleeping. My knee was bothering me. I'd had surgery a month prior. I got up around 11 p.m. to take my pain medication, and I looked out the window while I was waiting for it to take effect. What did you see? I saw Sarah, Miss Collins, loading items into the trunk of her car. Boxes, I think, maybe bags. It was dark, so I couldn't see clearly, but she made several trips from her house to the car. Sarah felt her chest tightened. She had no memory of loading anything into her car that night. She had been home grading papers and watching a documentary about the Civil War. Did you find this behavior unusual? I did. It was late for that sort of activity, and she seemed in a hurry. I wondered if she was leaving town. Thank you, Mr. Yates. Brennan returned to his seat, looking satisfied. Linda stood, gathering her papers with deliberate care. Mr. Yates, you mentioned you'd had knee surgery a month before September. Were you taking medication for pain? Yes, hydrocodone, as needed. And you were taking it the night you observed this activity? Yates nodded. I'd just taken a dose before looking out the window. Does the medication affect you at all? Make you drowsy or foggy? The bottle says it may cause drowsiness and confusion. I try to be careful with it. Linda walked to the evidence table and picked up a photograph. Mr. Yates, this is a photo of Miss Collins' car, a blue Honda Accord. Is this the vehicle you saw? Yates squinted at the image. It looked like that, yes, blue sedan. Are you certain it was Miss Collins loading items, or did you see a blue sedan and assumed it was hers? The elderly man hesitated. The car was in her driveway. But you couldn't clearly see the person's face in the dark. No, but who else would it be? That's a reasonable assumption, Linda acknowledged, but assumptions aren't the same as certainties. How far is your window from Miss Collins' driveway? I'm not sure exactly. According to property records, approximately 200 feet, and this was at night through your window, while you were taking medication that can cause confusion. Yates looked uncomfortable. I saw what I saw. I'm not suggesting you're lying, Mr. Yates. I'm suggesting that in low light, at a distance, while medicated, you may have seen a blue car in that driveway and made an honest mistake about who was there and what they were doing. Objection, Brennan interjected. Counsel is testifying rather than questioning. Sustained. Ms. Pacheco, ask questions. Linda nodded. Mr. Yates, is it possible you saw someone other than Miss Collins that night? The elderly man gripped his cane tighter. I suppose it's possible. Is it also possible that what you interpreted as boxes or bags could have been something else entirely? I can't be completely certain of the details. Thank you for your honesty. No further questions. As Yates made his slow way back to the gallery, Sarah felt a strange mixture of relief and unease. His testimony had been damaging, but Linda had planted sufficient doubt. Still, the image lingered. A blue car, someone loading items in darkness. If it hadn't been her, then who? Judge Holloway glanced at the clock. We'll take a brief recess before the next witness. During the break, Linda leaned close to Sarah. Yates isn't malicious, just mistaken, but Brennan will try to use his testimony to suggest you were hiding the jewelry before staging the burglary. I wasn't loading anything into my car that night. I was home alone.
I believe you. But someone was in that driveway. Someone driving a car similar to yours. Sarah's mind raced. Trevor drove a BMW, black, not blue, but rental cars came in every color. Could Trevor have rented a car? Linda made a note. I'll have our investigator check rental company records. If Trevor rented a blue sedan around that time, it changes everything. Court resumed, and Brennan called his final witness of the day, a forensic analyst who testified about the superficial nature of the damage to Sarah's back door, suggesting it had been created from the inside rather than forced from outside. The testimony was technical, filled with terms like directional splintering and force vectors. Sarah watched the jurors' faces, trying to gauge their reactions. Some looked engaged, taking notes. Others seemed confused or simply tired. By the time Judge Holloway dismissed court for the day, Sarah felt hollowed out. She had sat through hours of people dissecting her life, her relationship, her supposed motivations. She had listened to a neighbor describe seeing someone who may or may not have been her, doing something she had no memory of doing. Outside the courthouse, Jessica caught up with them. You did great in there, Sarah told her. I just told the truth. Jessica pulled her into a brief hug. We'll get through this. As they walked toward the parking lot, Sarah noticed a blue Honda Accord, the same model as hers, parked 2 rows over. Her stomach clenched. How many blue Hondas were there in this county? Hundreds, probably. Thousands. One of them had been in her driveway on September 12th, and she was going to find out who had been driving it. The courtroom felt different on the 4th day of trial. Sarah sensed it in the way jurors looked at her, not with certainty of guilt, but with something more complex. Curiosity, perhaps, or doubt about what they'd been told. Linda stood to call her first witness. The defense calls Dr. Raymond Porter. A man in his early 50s walked to the witness stand, carrying himself with the careful precision of someone accustomed to having his words scrutinized. His graying beard was neatly trimmed, and he wore a dark suit that suggested professionalism without ostentation. After being sworn in, Linda approached. Dr. Porter, please state your occupation. I'm a digital forensic specialist. I've worked in the field for 23 years, primarily consulting on criminal cases involving electronic evidence. Have you examined the computer and phone belonging to Sarah Collins? I have. I was retained by the defense to conduct an independent forensic analysis of both devices. Linda displayed a document on the screen, a detailed technical report dense with timestamps and metadata. Dr. Porter, the prosecution introduced evidence that Miss Collins's computer contains search history related to filing police reports and obtaining restraining orders. Did you examine this search history? Yes, the searches were conducted on September 9th and 10th of this year. Can you explain what metadata tells us about these searches? Porter adjusted his glasses, warming to his subject. Metadata includes information beyond just what was searched. It records the exact time of each search, the IP address, the device used, and in some cases, geolocation data. It's essentially a digital fingerprint of the activity. What did the metadata reveal about these particular searches? The searches attributed to Miss Collins occurred at 9:23 a.m. on September 9th and at 10:15 a.m. on September 10th. Both searches were conducted from her home IP address. Is there anything significant about those times? According to employment records provided by Haddonfield High School, Miss Collins was teaching classes during both of those time windows. Specifically, she was teaching second period on the 9th and third period on the 10th. Her classroom is 3 miles from her residence. A murmur rippled through the courtroom. Sarah watched the jurors' expressions shift as they processed this information. Brennan rose quickly. Objection. The witness is assuming Miss Collins couldn't have accessed her computer remotely. Judge Holloway looked to Porter. Can you address that concern? Yes, Your Honor. I examined the computer for any remote access software or applications that would allow external control. None were installed. Additionally, the school's internet policy blocks most external connections during school hours. For Miss Collins to have conducted these searches, she would have needed to be physically present at her home computer. Linda continued. In your professional opinion,
Ion, what does this suggest? It suggests that someone other than Miss Collins conducted these searches using her computer while she was verifiably elsewhere. Is there any other evidence of unauthorized access to her devices? Porter consulted his notes. The phone analysis revealed something equally concerning. The threatening text messages Miss Collins received came from an unregistered number, what's commonly called a burner phone. I was able to trace the number through cellular provider records. What did you find? The number was associated with a prepaid phone purchased at a convenience store in Cherry Hill on August 28th. The purchase was made with cash, so there's no credit card record. However, the store security footage from that date still existed. Linda displayed a grainy but discernible security image. A figure stood at the counter, face partially visible. Can you identify this person? Based on comparison with identification photos, this appears to be Trevor Hammond. The courtroom erupted in whispered conversations. Judge Holloway struck her gavel twice. Order. Sarah stared at the image. Trevor, buying the phone that would later send her threatening messages. Trevor, who had sworn under oath he had nothing to do with those texts. Brennan was on his feet.
Your Honor, this evidence wasn't disclosed during discovery. The defense is ambushing the prosecution. Linda responded calmly. The forensic analysis was completed only 72 hours ago. We provided copies to the prosecution immediately upon receipt, as required. Mr. Brennan received this report yesterday afternoon. Judge Holloway frowned. Mr. Brennan, did you receive the report? Yes, but there wasn't adequate time to review. That's not a discovery violation, Counselor. You may address the evidence on cross-examination. Objection overruled. Linda turned back to Porter. Dr. Porter, you mentioned examining Miss Collins's computer for unauthorized access. Did you find any evidence of how someone might have gained access? The computer showed no signs of sophisticated hacking. However, it didn't require hacking. According to Miss Collins's statement, Mr. Hammond had stayed at her residence regularly for 2 years. He would have had ample opportunity to learn her password simply by observation. So someone with previous intimate access to her home could have used her computer without her knowledge. Correct. And the timing of these searches, conducted during school hours when Miss Collins was verifiably absent, strongly suggests exactly that scenario. Thank you, Dr. Porter. No further questions. Brennan approached the witness stand with visible tension in his shoulders. Dr. Porter, you testified that the phone used to send threatening messages was purchased by someone who appears to be Mr. Hammond. Can you confirm with absolute certainty that the person in that security footage is him? Facial recognition analysis suggests a 92% probability match, but not 100%. Facial recognition is rarely 100% certain from security footage. 92% is considered highly reliable. Considered by whom? By forensic standards across law enforcement and digital investigation. Brennan switched tactics. You stated that Miss Collins's computer showed no remote access software, but couldn't she have simply deleted such software after using it? Deleting software leaves traces in system logs and registry files. I found no such traces, but a sophisticated sufficient user could cover their tracks. Porter shook his head. Miss Collins is a high school history teacher. Her computer usage patterns suggest basic proficiency: email, web browsing, word processing. The level of technical knowledge required to install remote access software, use it, delete it, and scrub all traces of its existence is far beyond what her usage history indicates. You're making assumptions about her technical abilities. I'm making forensic conclusions based on evidence. Brennan paused, visibly frustrated. No further questions. As Porter stepped down, Linda leaned toward Sarah. That was strong. The jury saw that the evidence against you was manufactured. Before Sarah could respond, Linda stood again. The defense calls Detective Owen Marshall. Marshall looked surprised as he walked back to the witness stand. He had clearly expected his testimony to be finished. Linda approached with the document in hand. Detective Marshall, during your initial investigation, did you attempt to trace the threatening text messages Miss Collins received? Marshall shifted uncomfortably. We noted the messages and their content. But did you trace the number through the cellular provider? We determined it was an unregistered number. Tracing unregistered numbers is difficult without a subpoena, and we didn't feel it was necessary given that you'd already decided Miss Collins was lying. Objection, Brennan called. Argumentative. Sustained. Linda rephrased. You closed the investigation without pursuing that avenue of inquiry. Is that accurate? We pursued the avenues that seemed most relevant. Dr. Porter was able to trace that number in a matter of days. Why didn't the police department invest that same effort? Marshall's jaw tightened. We allocated resources based on the evidence we had at the time. Evidence that you interpreted through the assumption that Miss Collins
was guilty. Detective, when you examined Miss Collins's computer, did you check the metadata on those search queries? We noted the dates of the searches. Not the specific times, not whether those times corresponded with her work schedule. We didn't consider that relevant. You didn't consider it relevant that the defendant was physically somewhere else when incriminating searches were allegedly conducted? Marshall's face flushed. We conducted a thorough investigation based on what? 4 days of investigation, no forensic analysis of computer metadata, no tracing of the threatening messages, no examination of Mr. Hammond's financial records or potential motives? Objection, Brennan said wearily. Asked and answered. Judge Holloway nodded. Sustained. Move on, Miss Pacheco. Linda gathered her papers. Detective Marshall, in your 28 years of police work, have you ever investigated a case where evidence was planted to frame someone? Marshall hesitated. Yes. And in those cases, what were the warning signs? Typically, evidence that seems too convenient, situations where everything points in one obvious direction. Like a burglary where only jewelry is taken, no fingerprints are found except those of the victim and one suspect, and the victim has recently made online searches about filing police reports. Marshall said nothing. That didn't seem too convenient to you? In retrospect, perhaps we should have looked deeper. In retrospect, Linda repeated quietly. No further questions. As Marshall left the stand, Sarah noticed something she hadn't seen before. The detective looked less like a confident investigator and more like someone who'd missed something crucial and knew it. Judge Holloway checked the time. We'll break for lunch. Court will resume at 1:30. In the courthouse cafeteria, Sarah pushed food around her plate without eating. Jessica sat across from her, offering quiet support without pressing conversation.
Linda reviewed her notes, occasionally making annotations of sharp, decisive strokes. "The afternoon will be difficult," Linda said finally. "Brennan will try to recover ground. But we've established reasonable doubt. The jury has seen that the investigation was incomplete and that evidence was potentially manufactured." Sarah set down her fork. "Do you think they believe me now?" Linda met her eyes. "I think they're questioning what they were told. That's all we need. Reasonable doubt. The prosecution has to prove guilt beyond that threshold. We just have to show that other explanations exist. Other explanations like Trevor breaking into my house, stealing my jewelry, and framing me for it." Exactly like that. Sarah looked out the cafeteria window at the gray November sky. Somewhere out there, Trevor was continuing his life, selling houses, playing poker, projecting the same charm that had fooled her for 2 years. But now that charm was cracking, and Sarah intended to watch it shatter completely. The woman who walked to the witness stand that afternoon looked as though she'd rather be anywhere else. Emma Gallagher was 39, with platinum blonde hair cut in a sharp bob that framed delicate features. She wore a gray pantsuit and minimal jewelry, and her hands trembled slightly as she was sworn in. Sarah had never heard Trevor mention anyone named Emma, but from the way his expression hardened when she entered the courtroom, Sarah understood immediately that this woman represented something he'd wanted to keep buried. Linda approached with gentle professionalism. "Miss Gallagher, thank you for coming. I know this isn't easy. How do you know Trevor Hammond?" Emma's voice was quiet but steady. "We were in a relationship from 2016 to 2019, 3 years. Can you describe that relationship?" Emma took a breath, visibly steeling herself. "It started well. Trevor was charming, attentive, successful. He made me feel special. For the first year, everything seemed perfect. What changed? Gradually, he became more controlling. He wanted to know where I was at all times. He'd show up at my workplace unexpectedly to surprise me. He started commenting on my clothes, my friends, how I spent my money. It felt like I was being managed rather than loved." Sarah felt something cold settle in her stomach. She recognized every detail Emma described. Linda continued carefully. "Did the relationship end amicably?" "No. I told Trevor I wanted to break up in March 2019. He became angry. Not violent, but intense. He said I'd regret leaving him, that I didn't understand what I was giving up. I changed my locks the next day." "Why did you change your locks?" "Because Trevor had a key to my apartment, and something in his reaction frightened me. He'd never been physically aggressive, but there was an edge I hadn't seen before." "What happened after you changed the locks?" Emma's hands gripped the armrests of the witness chair. 2 weeks later, Trevor called the police and claimed I had stolen $8,000 from him. He said he'd kept cash in a safe at my apartment, and that it was missing after the breakup. "Had you taken any money?" "Absolutely not. I didn't even know he kept cash there. But suddenly I was being questioned by police, being treated like a criminal. I had to hire a lawyer. It was humiliating and terrifying." "What was the outcome?" "After 3 weeks, Trevor suddenly dropped the accusation. He said he'd found the money, that had been in his car the whole time, that he'd made an honest mistake. The charges were dropped, but the damage was done. I'd spent $4,000 on legal fees, and my reputation at work had been damaged." Linda paused, allowing the jury to absorb this. "Miss Gallagher, do you believe Trevor actually lost that money?" Brennan stood immediately. "Objection, speculation. Your Honor, the witness has direct knowledge of the situation." Judge Holloway considered. "I'll allow it. The witness may answer." Emma met Linda's gaze. "No, I don't believe he ever lost it. I think he tried to punish me for leaving him, and when he realized it wasn't working, he backed down." "Have you had any contact with Trevor since 2019? "None. Until I saw news coverage of this trial. When I heard the details, a woman being accused of fabricating a crime to frame her ex-boyfriend, it felt sickeningly familiar. I contacted your office because I thought my experience might be relevant." "Thank you, Ms. Gallagher. No further questions." Brennan approached, and Sarah could see the calculation in his expression. Emma was a sympathetic witness, and attacking her would risk alienating the jury, but letting her testimony stand unchallenged would be devastating. "Ms. Gallagher, you testified that you were in a relationship with Mr. Hammond from 2016 to 2019. That ended 4 years ago, correct?" "Yes." "People change in 4 years." Emma's expression didn't waver. "Patterns of behavior don't usually change without intervention. You're not a psychologist, are you?" "No, but I spent 3 years with Trevor. I learned to recognize his patterns." Brennan shifted tactics. "You mentioned that you've had no contact with Mr. Hammond since 2019. Say you have no direct knowledge of his relationship with Miss Collins." "That's correct." You're basing your testimony on assumptions about similarity between your experience and Miss Collins's situation. I'm testifying about what Trevor did to me. The jury can decide whether they see parallels. Brennan consulted his notes, clearly searching for a better angle. Ms. Gallagher, you stated that you had to hire a lawyer when Mr. Hammond made accusations against you. You also mentioned spending $4,000 in legal fees. Were you upset about that expense? Of course I was upset. I was being falsely accused. Upset enough to want revenge? Emma's jaw tightened. I moved on with my life. I went to therapy, processed what happened, and rebuilt. I'm here because I saw another woman going through something similar, and I thought I could help. That's not revenge. That's conscience. Brennan paused, recognizing he was losing ground. You mentioned going to therapy. What were you being treated for? Linda stood sharply. Objection. The witness's medical history is not relevant. Your Honor, Brennan argued, the witness's credibility is at issue. If she was receiving psychiatric treatment. Objection sustained, Judge Holloway interrupted, her tone icy. The witness sought counseling after a traumatic experience. That demonstrates good judgment, not instability. Move on, Mr. Brennan. Brennan's frustration was visible now. Ms. Gallagher, isn't it true that you have no actual evidence Mr. Hammond fabricated his accusation against you? That it's possible he genuinely misplaced money and made an honest mistake? Emma leaned forward slightly. Mr. Brennan, Trevor told me exactly where the money was supposed to be, in a safe in my bedroom closet. When police searched my apartment, there was no safe. There had never been a safe. Trevor described something that didn't exist. That's not an honest mistake. That's a fabrication. The courtroom was silent. Brennan stood frozen for a moment, then returned to his seat. No further questions. As Emma stepped down, she glanced briefly at Sarah. Their eyes met, and Sarah saw understanding there, the recognition of two people who had survived the same storm. Judge Holloway announced a short recess. During the break, Linda received a manila envelope delivered by courier. She opened it, scanned the contents, and her expression shifted into something Sarah couldn't quite read. What is it? Linda looked up. This is from Emma Gallagher. She had a private investigator look into Trevor after her case was dropped. She's been holding on to this information for years, but after testifying today, she decided we needed to see it. She spread several documents across the defense table. Sarah leaned in to read. Bank statements, showing an account in Trevor's name at a bank in the Cayman Islands. And deposits, multiple deposits over the past 3 years, totaling nearly $50,000. He has an offshore account, Sarah breathed. Had, Linda corrected. Look at the dates of the most recent deposits. Sarah scanned down the page. September 16th, September 18th, September 21st, all within a week of her reported burglary. The deposits totaled $14,800, almost exactly the value of her stolen jewelry. Linda gathered the papers carefully. This changes everything, but we need to handle it strategically. If we introduce this now, Brennan will argue it wasn't obtained through proper legal channels. Emma got it from a private investigator years ago. That's legal. It's legal for her to have obtained it. Whether it's admissible in court is a different question. We'll need to lay proper foundation. Court resumed. Judge Holloway.
Holloway looked expectantly at the defense table. Ms. Pacheco, your next witness? Linda stood. Your Honor, the defense has just received evidence that is highly material to this case. We request a brief recess to determine the appropriate way to introduce it. Brennan was on his feet. Your Honor, the defense has had weeks to prepare their case. They can't simply produce mystery evidence at the last moment. The evidence came into our possession less than an hour ago, Linda responded. It was provided by Miss Gallagher following her testimony. Given its significance, we believe the court should review it before we proceed. Judge Holloway considered, then nodded. I'll examine the evidence in chambers. Both counsel, approach. Linda, Brennan, and the judge disappeared through the door behind the bench. Sarah sat in silence, watching the minutes tick by on the courtroom clock. Jessica had slipped into the gallery during the recess, and now she leaned forward. What's happening? Emma gave us evidence, financial records showing Trevor deposited money right after the burglary, money that matches the value of my jewelry. Jessica's eyes widened. So he did it. He actually did it. It looks that way, but Linda said getting it admitted as evidence might be complicated. 20 minutes passed before the attorneys returned. Judge Holloway resumed her seat, her expression carefully neutral. After reviewing the materials, I've determined that the evidence in question is relevant and was legally obtained. However, given that the prosecution had no advance notice, I'm granting a recess until tomorrow morning. This will give Mr. Brennan time to review the documents and prepare an appropriate response. Court is adjourned until 9 a.m. The gavel struck. Sarah exhaled slowly, feeling the weight of the day settle over her. They were close, so close to proving what Trevor had done, but close wasn't the same as certain.
As they gathered their materials, Sarah noticed Trevor leaving through the front door, flanked by Brennan and another attorney. His face was pale, his confident swagger absent. For the first time since this nightmare began, Sarah allowed herself to feel something she'd almost forgotten: hope. But hope was fragile, and tomorrow, everything would depend on whether the jury believed what those bank statements revealed. Sarah just had to trust that the truth, after being buried for so long, would finally be strong enough to surface. The courtroom felt electric as proceedings resumed the next morning. Word had spread among courthouse staff and media that something significant was about to unfold, and the gallery was packed with observers who hadn't been present during earlier days of trial. Judge Holloway called the court to order with 2 sharp strikes of her gavel. "Miss Pachenko, you may proceed." Linda stood, holding a slim folder that suddenly seemed to carry enormous weight. "Your Honor, the defense moves to introduce Exhibit 47, financial records obtained through legal investigation showing account activity relevant to this case." She approached the bench, and Brennan joined her. After a brief sidebar conference, Judge Holloway nodded. "The exhibit is admitted. You may continue." Linda returned to the defense table and called her next witness. The defense calls Victoria Chen. A woman in her mid-40s walked to the witness stand, carrying herself with professional efficiency. She wore a charcoal suit, and her dark hair was pulled into a neat bun. After being sworn in, she settled into the chair with the posture of someone accustomed to testifying. "Ms. Chen, please state your occupation." "I'm a certified financial analyst specializing in forensic accounting. I've worked in the field for 19 years, primarily examining financial records in criminal and civil cases." "Have you reviewed certain financial documents related to this case?" "Yes, yesterday evening I was retained to examine banking records associated with an offshore account held by Trevor Hammond." Linda displayed copies of the bank statements on the screen. Sarah watched the jurors lean forward, studying the rows of numbers. "Can you explain what these records show?" Chen adjusted her reading glasses. "These are statements from an account at First Caribbean International Bank in the Cayman Islands. The account is held in the name of Trevor Hammond and was opened in July 2020. What kind of activity does the account show?" "Over the past 3 years, there have been sporadic deposits totaling approximately $47,000. The deposits vary in amount and timing, with significant gaps between some transactions." "Is there anything notable about the recent activity?" "Yes, there are 3 deposits made in September of this year, September 16th, 18th, and 21st. These deposits total $14,800. "How does that amount compare to the value of jewelry reported stolen from Miss Collins's residence?" "According to police reports, the stolen jewelry was valued at approximately $15,000. The deposits are within $200 of that amount." A murmur ran through the courtroom. Judge Holloway's expression remained neutral, but Sarah noticed her pen pause mid-notation. Linda continued. "Is there any indication of where these deposits originated?" "The deposits were made in cash at different branch locations in southern New Jersey: Cherry Hill, Voorhees, and Marlton.
Cash deposits are harder to trace than electronic transfers, but the timing and amounts create a clear pattern. In your professional opinion, what does this pattern suggest?" Brennan rose. "Objection. Calls for speculation." "Your Honor, Ms. Chen is a financial expert. Her professional interpretation is relevant." "I'll allow it. The witness may answer." Chen spoke with measured precision. "The pattern suggests someone converting physical assets, such as jewelry, into cash, then depositing that cash incrementally to avoid triggering reporting requirements. U.S. banks must report cash deposits over $10,000. By keeping deposits below that threshold and spreading them across time and location, someone could avoid automatic scrutiny." "Thank you, Ms. Chen. No further questions." Brennan approached, his earlier confidence replaced with visible tension. "Ms. Chen, you testified that these deposits were made in cash. Is there any direct evidence linking them to Miss Collins's jewelry?" "Not direct physical evidence, no. The analysis is based on timing, amounts, and pattern." "So you're making inferences." "I'm making professional conclusions based on forensic analysis. That's what financial experts do." "But you can't prove these deposits came from selling stolen jewelry." "I can prove they occurred immediately after a burglary and match the value of stolen property. The proximity is statistically significant." Brennan shifted tactics. "You mentioned the account was opened in 2020. Isn't it possible Mr. Hammond had legitimate reasons for maintaining an offshore account?" "It's possible. Many people have offshore accounts for legal purposes. However, the September deposits specifically are anomalous in their timing and method." "Anomalous isn't the same as criminal." "No, but combined with other evidence presented in this trial, it establishes a compelling financial motive and timeline." Brennan had no effective response. He returned to his seat looking like a man watching his case dissolve. Linda stood again. "The defense calls Nathan Burgess." An older man with weathered features and kind eyes made his way to the stand. He wore a casual button-down shirt and khakis,
and his hand showed the calluses of someone who worked with physical objects. "Mr. Burgess, what is your occupation?" "I'm a private jewelry dealer. I've been in the business for 32 years, buying and selling estate jewelry, antiques, precious metals." "Where is your business located?" "I operate primarily in Pennsylvania, King of Prussia, Philadelphia area. I also attend estate sales and private appointments throughout the Mid-Atlantic region." "Mr. Burgess, did you purchase any jewelry in September of this year?" "I did. On September 15th, a man contacted me about selling several pieces. We met at my office in King of Prussia the following day." "Can you describe the jewelry?" Burgess consulted a small notebook. "A sapphire pendant with white gold chain, pearl earrings with diamond accents, a gold bracelet approximately 14 carats, and 2 rings, one with a small ruby, one plain gold band. Beautiful pieces, well maintained." Sarah's breath caught. Those were her pieces. The sapphire pendant her grandmother had given her, the pearl earrings from her parents on her college graduation. Every item Burgess described had been in her jewelry box the morning of September 14th. Linda displayed photographs on the screen, photos Sarah had provided to police of her missing jewelry. "Mr. Burgess, are these the items you purchased?" Burgess studied the images carefully. "Yes, those are the same pieces." "How much did you pay for them?" $14,500. The sapphire alone was worth approximately $9,000. I typically pay 70 to 80% of estimated retail value. "Can you identify the person who sold you these items?" Linda displayed a photo array, 6 faces arranged in 2 rows. Sarah recognized Trevor's face in the top right position. Burgess pointed without hesitation. "That man, top right. He said his name was Tom Henderson, but I remember his face clearly." Let the record show the witness identified Trevor Hammond. "Mr. Burgess, why do you remember this transaction specifically?" 2 reasons. First, the jewelry was high quality, and the seller seemed nervous, kept checking his phone, asking how quickly I could complete the transaction. Second, when I later saw news reports about a burglary in Haddonfield involving stolen jewelry matching these descriptions, I contacted the police. "When did you contact the police?" Burgess's expression darkened. "No, I called twice more and left messages. No one ever returned my calls." Sarah felt anger surge through her. The police had been contacted by someone who had purchased her stolen jewelry, and they'd done nothing. They'd been too busy building a case against her to investigate the actual crime. Linda's voice remained calm, but Sarah heard the steel beneath it. "Mr. Burgess, how did you ultimately connect with the defense?" "Your investigator contacted me last week. When I explained the situation, I agreed to testify. I don't like being part of something criminal, even unknowingly." "Thank you. No further questions." Brennan approached, but his cross-examination
was perfunctory. Burgess was a credible, sympathetic witness with no apparent motive to lie. After a few weak questions about the certainty of his identification, Brennan gave up. As Burgess left the stand, Linda called Detective Marshall once more. Marshall walked to the witness stand with his shoulders slightly hunched, as if bracing for impact. "Detective Marshall, did you receive a phone call from Nathan Burgess on October 3rd regarding jewelry matching the description of items stolen from Miss Collins's residence?" Marshall's jaw tightened. "I don't specifically recall that call." "The call logs from Haddonfield Police Department show 3 calls from Mr. Burgess's number to the main line, requesting to speak with you. Do those logs refresh your memory?" "If the logs show it, then yes, he must have called." "Why didn't you follow up?" "By early October, we had already concluded our investigation and filed charges against Miss Collins. The case was with the prosecutor's office." "So you received information about a potential buyer of stolen jewelry, and you simply ignored it because you'd already decided Miss Collins was guilty?" Brennan objected, but Judge Holloway overruled him. Marshall's face flushed. "We believed we had sufficient evidence to support the charges. Even when new evidence emerged that contradicted your theory, I don't make charging decisions. That's the prosecutor's office." Linda let the silence stretch before continuing. "Detective, you testified earlier that you verified Mr. Hammond's alibi by confirming he used his casino card. Did you request any video surveillance from the casino?" "No." "Did you check whether Mr. Hammond rented a vehicle around the time of the burglary?" "No." Linda produced another document. "Records from Enterprise Rent-A-Car show that Trevor Hammond rented a blue Honda Accord on September 10th and returned it on September 13th. Were you aware of this?" Marshall's expression grew stony. "No. That's the same make, model, and color as Miss Collins's vehicle, the same vehicle that neighbor Philip Yates reported seeing in Miss Collins's driveway on September 12th. Did you investigate the possibility that Mr. Yates saw a rental car rather than Miss Collins's car? We had no reason to believe. You had every reason to investigate thoroughly. You simply chose not to." Linda returned to the defense table. "The defense has no further questions for this witness. However, Your Honor, based on the evidence presented, we move for dismissal of all charges against Sarah Collins." The courtroom erupted in noise. Judge Holloway struck her gavel repeatedly. "Order? This court will have order." When silence was restored, she looked at Brennan.
Mr. Brennan, the evidence presented raises serious questions about the investigation and the charges. How do you wish to proceed? Brennan stood slowly. He glanced at his assistant, then at Trevor, who sat pale and rigid in the gallery. Your Honor, the people request a recess to review this new evidence and consult with law enforcement. Denied. Mr. Brennan, you've had since yesterday evening to review the financial records. The jewelry dealer's testimony corroborates those records. You will proceed now. Brennan's shoulders sagged slightly. Your Honor, in light of the evidence presented, the people can no longer prove the charges against Miss Collins beyond reasonable doubt. We move to dismiss all charges. The words hung in the air for a moment before their meaning fully registered. Sarah felt Linda's hand grip her arm. Judge Holloway nodded slowly. Motion granted. All charges against Sarah Collins are dismissed. She turned to face Sarah directly. Miss Collins, you are free to go. This court apologizes for the injustice you have endured. The gavel fell one final time. Sarah sat frozen, unable to process what had just happened. Around her, the courtroom dissolved into chaos. Reporters rushing for exits, spectators talking in excited voices. Then Jessica was there, pulling her into a fierce hug, and the reality finally hit. It was over. She was free. 6 weeks had passed since Judge Holloway dismissed the charges. Sarah stood in her living room, looking at the new door that had been installed 3 days earlier. The contractor had done good work. Solid oak with a reinforced frame and a deadbolt that required a key from both sides. The back door had received the same treatment. The house felt different now, lighter, somehow, despite the gray January afternoon outside. Her phone buzzed with a text from Jessica. Coffee tomorrow? I want to hear about the first day back. Sarah smiled and typed a response. Tomorrow would be her first day returning to Haddonfield High School. The administration had been supportive throughout the ordeal, keeping her position open. But Sarah knew walking back into that classroom would be complicated. Her students had witnessed her arrest. They'd seen the news coverage. Some had probably believed she was guilty. But Sarah had spent 6 weeks in therapy working through the trauma, and her therapist had been clear. She couldn't let fear keep her from reclaiming her life. The doorbell rang. Sarah checked the security camera she'd installed, another new addition, and saw Linda Pacheco standing on the porch, carrying a leather portfolio. Sarah opened the door. Linda, I wasn't expecting you. I know, I should have called, but I wanted to deliver this in person. They settled in the living room.
Linda opened the portfolio and pulled out a document. Trevor Hammond was formally indicted yesterday. 3 counts of burglary, 2 counts of fraud, 1 count of perjury, and 1 count of filing a false police report. The prosecutor's office is also investigating potential charges related to the offshore account and money laundering. Sarah took the document, scanning the legal language that transformed Trevor from her former boyfriend into a criminal defendant. How long could he face? If convicted on all counts, potentially 15 to 20 years. The prosecutor is treating this seriously, especially given the attempt to frame you. Public sympathy is entirely on your side, which creates pressure for a strong response. Sarah set the papers down. I don't feel triumphant. I thought I would, but I just feel tired. That's normal. You've been through something profoundly traumatic. Justice doesn't erase that. Has Trevor said anything? Issued any kind of statement? Linda's expression hardened slightly. His attorney released a statement claiming the evidence is circumstantial and that Trevor looks forward to clearing his name. It's posturing. The evidence is overwhelming, and his attorney knows it. My guess is they'll eventually negotiate a plea agreement. Will I have to testify at his trial? Possibly, but that's months away, if it even goes to trial. For now, focus on your own recovery. After Linda left, Sarah found herself drawn to the box she'd kept in her closet, the box containing remnants of her relationship with Trevor. Photographs, ticket stubs from concerts, a birthday card he'd given her during their first year together. She carried the box to the kitchen and began sorting through its contents. Some items she placed in a pile for disposal. Others, the concert tickets, a few photos where she looked genuinely happy, she set aside. Those memories had been real, even if the person she'd believed Trevor to be had been largely fabrication. Her phone rang, an unknown number. Sarah hesitated, then answered. Miss Collins, this is Emma Gallagher. I hope it's okay that I'm calling. Linda gave me your number and said you'd be open to talking. Emma, yes, of course. Thank you for everything you did. Your testimony changed everything. I did what I should have done years ago. I'm sorry I didn't come forward sooner. They talked for 20 minutes. Emma described her own recovery process after her relationship with Trevor ended. The therapy, the gradual rebuilding of trust, the work of distinguishing between healthy caution and paralyzing fear. The thing I learned, Emma said, is that what happened doesn't define you. It's something that happened to you. There's a difference. After they hung up, Sarah felt something shift inside her. Emma was right. She'd been victimized, but she wasn't a victim. Those were distinct states of being. The following morning, Sarah dressed carefully for her return to school. Professional but not defensive. A navy sweater and gray slacks. Minimal jewelry. She'd replaced the stolen pieces with simpler items.
The drive to Haddonfield High School took 12 minutes. Sarah parked in her usual spot and sat for a moment, gathering herself. The hallways were familiar but felt strange after 2 months away. Students passed in clusters, some glancing at her with curiosity. Word had spread fast that she was returning. Principal Morrison met her outside her classroom. "Sarah, welcome back. If you need anything at all, my door is open." "Thank you. I appreciate that." Morrison hesitated. "The students have questions. We've instructed staff not to discuss the case directly, but I want you to know we support however you choose to handle it." Sarah nodded. She thought about this extensively. Avoiding the subject would make it larger. Addressing it directly might provide closure. Her first period class filed in quietly, 23 faces watching her with varying degrees of curiosity and uncertainty. Sarah recognized most of them, juniors she'd taught the previous semester. She set her bag down and turned to face them. "I know the past few months have been strange and probably confusing. Some of you saw me arrested. You've seen news coverage. You have questions." She paused. "I'm not going to pretend nothing happened. I was accused of something I didn't do. The legal system eventually worked the way it's supposed to, and the charges were dismissed. The person actually responsible is now facing prosecution." A hand went up. Sarah nodded. "Miss Collins, were you scared?" "Yes, I was terrified. I was facing the possibility of prison for something I hadn't done. It was the most frightening experience of my life." Another hand. "What kept you going?" Sarah considered the question. "Honestly, the knowledge that the truth existed, that there were facts, evidence, records, testimony, that would eventually reveal what actually happened. I teach history because I believe in the power of evidence and truth. This experience tested that belief, but ultimately reinforced it." The class was silent for a moment. Then a gal in the back row spoke without raising her hand. "We're glad you're back." Several other students murmured agreement. Sarah felt her throat tightened but kept her composure. "Thank you. That means more than you know. Now let's talk about reconstruction." The lesson proceeded normally. Sarah fell back into the familiar rhythm of teaching. Questions and answers, discussions, a careful work of helping students understand complex historical events. By the end of the day, Sarah felt exhausted but grounded. This was her life. This classroom, these students, this work she believed in. 3 weeks later, Sarah received notification that Trevor's attorney had negotiated a plea agreement. Trevor pled guilty to burglary, fraud, and perjury in exchange for a recommended sentence of 12 years. The sentencing hearing was scheduled for late February. Sarah debated whether to attend. Part of her wanted closure, wanted to face Trevor one final time and deliver a victim impact statement. Another part wanted to simply move forward without looking back. In the end, she decided to attend. The courtroom was less crowded than during her own trial. Sarah sat in the gallery with Linda beside her. Trevor entered in an orange jumpsuit, his hands cuffed. The transformation was startling. The polished, confident man she'd known had been replaced by someone who looked diminished and exhausted. Judge Holloway presided over the hearing. After accepting Trevor's guilty plea, she asked if Sarah wished to make a statement. Sarah walked to the podium. She'd written something, but decided to speak from memory. "Trevor Hammond stole my jewelry. But more than that, he tried to steal my freedom, my reputation, and my future. He calculated that the system would believe him over me. He was almost right." She paused. "I don't forgive what he did, but I also won't let what he did define the rest of my life. I'm here today to reclaim my narrative, to state clearly that I survived this, and I will continue surviving." She returned to her seat. Trevor never looked at her. Judge Holloway sentenced him to 12 years with possibility of parole after 8. Trevor was led away without incident. Outside the courthouse, reporters asked for statements. Sarah kept her response brief. "Justice was served today. I'm grateful to everyone who believed in the truth and fought to reveal it. Now I'm focused on moving forward." Spring arrived gradually. Sarah's garden began to show green shoots, daffodils and tulips she'd planted the previous fall, before everything fell apart. She found unexpected satisfaction in the physical work of gardening, in the tangible evidence that things could grow and bloom after periods of darkness. Jessica visited one Saturday in April, bringing coffee and pastries. They sat on Sarah's back porch, watching clouds drift across a perfect blue sky. "You seem different," Jessica observed. "Calmer. I feel different, like I've been tested in a way I never expected, and discovered I'm stronger than I thought." "You were always strong, you just didn't know how much." Sarah considered this. Maybe. Or maybe strength is something that develops through being broken and choosing to rebuild. In May, Sarah received a letter from Emma Gallagher. Emma had started a support group for people who'd experienced intimate partner manipulation and legal abuse. She invited Sarah to speak at one of their meetings. Sarah accepted. Standing before a room of 20 people who'd endured similar experiences, Sarah told her story. She emphasized the importance of documentation, of trusting instincts, of seeking help. But mostly, she emphasized hope. "What happened to me was terrible," she said. But it ended. The truth emerged. Justice was imperfect, but ultimately functional. You can survive this. You can rebuild. Afterwards, several people thanked her. One woman, younger than Sarah, gripped her hand tightly. "I needed to hear that it's possible to get through this. Thank you." Driving home that evening, Sarah realized she'd found something unexpected in the wreckage of the past year. Purpose. Summer brought long evenings and the satisfying rhythm of a teacher's break. She traveled to Vermont, spending a week in a small cabin near a lake. She hiked, read, and simply existed without the weight of constant vigilance. On her last evening there, she sat on the cabin's small dock watching the sunset paint the water gold and crimson. Her phone buzzed with a text from Linda. "Trevor's appeal was denied. Sentence stands." Sarah read the message and set her phone aside. She felt relief, but not satisfaction. Trevor's punishment didn't undo what had happened. It didn't restore the innocence she'd lost about how easily systems could fail and truth could be obscured. But it did represent closure. The water lapped gently against the dock. A loon called across the lake, its cry haunting and beautiful. Sarah thought about the question her students had asked. What kept you going? The answer was more complex than she'd articulated that day. It wasn't just belief in truth. It was also stubbornness and fear, and the support of people like Linda and Jessica and Emma. It was the small acts of showing up each day even when everything felt impossible. Most of all, it was the refusal to let someone else's cruelty determine her story. Sarah Collins had been accused, arrested, and nearly convicted of a crime she didn't commit. She had been betrayed by someone she'd trusted, and failed by a system designed to protect her. But she had survived. And survival, she'd learned, wasn't passive. It was a choice made repeatedly, day after day, to rebuild and reclaim and refuse to surrender to fear. The sun dipped below the horizon. Darkness gathered, but Sarah wasn't afraid of it anymore. She'd learned that darkness was temporary, and she'd learned she was strong enough to wait for dawn.